My name is Frank Bruno. How do I protect my home and life savings? I'm an attorney in Queens, New York. I handle the 5 boroughs, Nassau and Suffolk, and I've been in practice for about 30 years. I'm in Glendale since 1997 in a practice that has a number of other people that assist. So the paralegal that assists me most with estate planning is Josephine. I have Erin, who does a lot of follow-up, Carla, who answers phones, and Sebastian. He's an attorney that works with me here in the office on issues related to contested matters, far and away, mostly contested matters. You can find me on Myrtle Avenue. The landmarks are a very famous restaurant in the area, Zum Stammtisch, German food. I'm on the same block as Russo's Bakery. It's another famous place. All of my landmarks are food. I'm not too far away from a Dunkin' Donuts either. My personal practice involves estate planning, guardianship, and issues related to elder law, the elder law experience, Medicaid asset protection planning, things of that nature. Okay, what are we going to learn today? We're going to learn about estate planning, and I hope that the time goes by quickly. And even if it goes by in a long time, it'll be the same amount, right? So either it's fun or not fun, but you'll be here for about an hour anyway. And I really hope that you learn a lot. What am I showing you? Well, the framework of estate planning is theoretically what happens at the time of your passing, where do your assets go, and how do they go? And then the framework is what are the threats known and unknown to your family? We boil it down to 7. It could be 42, right? And it could be less than that. Losing control or access of your assets, not knowing the law, not knowing the creditors. Who are they? Creditors, the government, people you owe money to, medical claims, your health, right? That's a threat to your family, being in poor health, failing to plan when you can. So I could plan now. I'm healthy, robust, vibrant. I can think for myself. This is when I should plan. I shouldn't wait until some future catastrophe. And I have many people that come at a little bit too late. Not working with qualified professionals. I submit to you, I am a qualified professional and you should work with me in my office and not knowing the costs, the real costs. So it's not the cost of a plan as compared to no plan. It's the cost of a plan compared to what you can save or what you can preserve. Losing control of your estate. So what is your estate and what is estate planning? I'm going to go through that. But basically, and there are many different versions and definitions of these things, but I would tell you that your estate assets are all of the stuff of life. Any real property that you own, any personal property that you own, any stocks or bonds, or all of that. And what is estate plan? It's a plan for who gets what and when. What, when, and how. And how it will be managed at the time of your passing, or more and more frequently, we're seeing people involved in an incapacity, the onset of an illness. And then when I say potentially at an incapacity or at the time of death, it could be some other event. You could say, I want the money in this account or the home that I own. I want it to go to my oldest grandchild when they reach the age of 50, or I want the sum of X dollars to go to this person 10 years from now. It could be complicated. It could be simple. It could be very involved and detailed, or it could just be upon my passing, I have 3 children, A, B, and C. I'd like the entirety of my estate to go 1/3 to A, 1/3 to B, and 1/3 to C. So as an elder law focused attorney, an estate plan is a plan for how you would manage it in the event that you have an incapacity and can't manage it. So we plan in advance in case that's a contingency, and then how will be managed then, and who's going to manage it. It's a person that you choose, and in the way in which you choose. So we think about it in advance. And then without proper planning, it could be that you're subject to the court in a guardianship proceeding, or fighting among your children or relatives, depending on your facts. If I had to break down the fundamentals of estate planning, and I don't really have to break them down, but why not? We're on a seminar, we're on a webinar. So estate planning comes down to 3 things. The acronym ACT, ACT. access, control, and time. Who is in control, who gets the benefit, and when. So as I mentioned, I'm alive, healthy, well, with full capacity. I get to decide. I'll use the next slide. I get to decide if I'm alive and well, or when I'm alive and well. If I have an accident, if I have an illness, if I have incompetence, right? The legal word is incapacity, but people think about it as this person is not competent. They're incompetent. Who gets to decide? And then death. What way are we spreading out the assets across family, friends, church, synagogue, mosque? How are we distributing assets? Not knowing the law, what and how does your state distribute your assets in the event of no claim? So I'm going to give you some terms. The estate is your stuff, and so in going over an estate, your estate is simply all of your assets, all of the things that you own, personal belongings, your house, other real property, investments, any cash in cash accounts, whether it be a bank account, savings, checking, money market, retirement accounts, IRA, 401k, any stocks or bonds that you might own. Your estate would include the ownership of insurance policies. That's your estate. Types of ownership: joint ownership, payable on death ownership, transfer on death, and in trust for. A prospective client told me that their house was in a parent's name, parents and siblings, and they wanted to transfer it. Then we need to know, well, is it joint? Is it tenants in common? What way in which is the property owned? And then we can discuss why you want to transfer assets during life. And if that's a reasonable plan, would it make sense to put that property into a trust or another vehicle and transfer it at some later point to gain all of the benefits of a stepped up basis or some other reason? Advanced directives, that's your power of attorney, healthcare proxy, living will. Then you have your designations, beneficiary designations, that is. So upon my death, I want this account to go to my adult child. There's a trust, I have a slide on trust, and there's a will. I'm going to go in detail about the last one, testament. So a will is a legal document, should be created by an attorney. You might want to attempt a Staples or an Office Depot will, but I don't think you should. It's not just for me. You can go to any lawyer and do a will, but if you're looking to transfer assets, several $1,000s to hundreds of thousands of dollars, why would you go with a $69 will without a professional? The magic in the will is the execution and the execution ceremony. So it's good to have that done within an attorney's office with proper witness. So what's a will? A will is this document that names an executor, names who gets what, that's your beneficiaries, and who's in charge. So it controls what you own in your individual name. So if I have a house and I own that house with my wife, if my will says I want my house to go to my children, A, B, and C, oddly named kids, right? But for simplicity, I want my house to go to my kids. Well, in the example I gave, I own that property with my wife. By operation of law, at my passing, it will go to my wife and it will bypass the will. So the will only affects assets in your individual name, and it's only valid upon death. So, and you must go to probate, and it doesn't control jointly held assets, and it doesn't control beneficiary designation. So you may think you're protected with a simple will, and possibly you are, but it depends on your ownership of various asset classes, and a will guarantees that you go through probate, and certainly a will is better than doing no estate planning, but there are drawbacks. As I just mentioned, the nature of only controlling your distribution at your death and only controlling assets that are in your individual. What's probate? Probate is the act of taking a validly executed will, having the executor bring that will and a probate petition to court, and the court grants the permission and authority for the executor to distribute funds. That's what a probate. It's a court proceeding. In New York, it takes place in the surrogates court. Other states, other jurisdictions may call it probate court. In New York, we call it surrogates court. It orders the payment of debts and taxes. And if you have an asset, if the decedent, the person that passed away, has an asset in their individual name, this is the only way to transfer title upon death. Why would we want to avoid probate? Well, it is a court proceeding, and we try to avoid court proceedings whenever possible. So if you can avoid probate through some small action, such as creating a living trust, revocable trust, or an irrevocable trust, that may be the way to go. Again, we'd have to talk to you about your situation. And I do these consults and I speak to you on the phone. I speak to you in person, speak to you on Zoom. We can have a dialogue about what you have, where you have it, and what you want to happen. So the first reason we might want to avoid probate is because of costs. If you have assets of $500,000 or more, the fees for probate are $1,250. Probate fees can be 3 to 8% of the gross value of the estate. Attorneys' fees range based on the complexity of the case. A probate can be contested. The proposed executor can be challenged. So if you know that you have a sticky family dynamic, you have a busybody sibling, you may avoid probate. And any cost that you pay for probate ultimately comes from the assets of the estate, and it reduces the amount that all heirs can share. Why else would you want to avoid probate? Well, delay. Pre-pandemic, I used to say 3 to 6 months. I have amended that 6 to 9 easily. 6 to 9 months from taking the will, bringing it to court, to getting that letters of administration. That, as I mentioned, is the permission and authority of the court for the executive to distribute assets. So if we're talking about a delay of, on average, 9 months, none of the heirs can get the asset, and they can't access the money, and they have no money for the payment of bills or mortgage or taxes or water or insurance. So all of that makes it up in the air, and you can't distribute. So the third reason to avoid probate is because of publicity. So what do I mean by publicity? Well, a will itself is a document that's not required to be filed anywhere. A will can be in your sock drawer. It could be in the cabinet. It could be in your lawyer's office, sometimes in a bank, in a locked box or a safe deposit box. And why do people do that? Because it's a private document and you don't want people to see it. Well, when your estate goes through probate, a notice is placed in the newspaper often enough. It lets the community know that your estate is in probate, and the file is available in the county courthouse for anyone to see it and read it. And this is an invitation for creditors or disgruntled heirs to challenge it. Okay. So, and a disgruntled creditor or heir can make a claim against the estate because it's public. And the way the court works is that you need beneficiaries and potential beneficiaries to sign a waiver. And if they don't sign a waiver, that really makes it a will contest, in the sense is that you have to file a proposed citation and secure a court date. So just the act of relatives, siblings, not signing a waiver, it requires you to get a court date, and that's basically a will contest, or at least the start of a will contest. And then the fourth reason is loss of control. Once you involve the court is in control and not family members. So to sum it up, probate is expensive, it's lengthy, and it's a public process. It's not a pleasant experience for anyone, and your family could miss out on a significant portion of the assets, because any dollar spent on either the filing fee, the court process, or a will contest is taken directly out of the beneficiary's pocket. This is another good reason. Multi-state probate. So if a person owns property in New York and New Jersey, New York and Florida, New York and Pennsylvania, I can mention all the states, but that's what we see often enough, those 3 states. If a person owns property in those other states and they have a will, you have to probate first in New York and then do an ancillary probate in that other jurisdiction, and it costs time and money. What's a trust? Well, I'm going to make this slide quick because I have some other slides on trust. There's a testamentary trust. That's a trust built into a will. And then there are living trusts, which, as the name may imply, it's made during the life of the grantor while the person is alive. I'm alive, I can make a living trust. It's in place of a will. It's like a will on steroids. I don't know, this is muscles, a strong will. A trust is like a strong will. And then there are special needs trusts, which are beyond the scope of today's webinar, but that really affects people that have special needs or developmentally disabled. What is a trust? It's created while a person is living. And this, I think, is what we came here to learn about. Why do we use this? Well, it's a separate legal entity it's prepared and becomes alive while you're alive, and it lives on after your passing. The idea would be you take your assets and you legally, permissibly create the trust first. You take your asset, you place them into the trust, you retitle, and any asset inside of the trust avoids probate. And the idea is, upon your death or incapacity, they're already under the control of a trustee. Now, in a revocable living trust, that trustee can be you. And in an irrevocable living trust, that trust can be whoever you choose. So a spouse, your oldest living child, your youngest child, any adult, a friend, whoever you trust, right? That's what the name implies. Trustee, I trustee you. So the grantor sets it up and directs it. The trustee or co-trustees manage the trust assets. Trustees have complete control over the management of the assets. So the trustee can buy or sell or do anything that's permissible within the trust. The trustees follow the trust's specific instructions for paying debts, for distributing benefits to the beneficiaries. You name beneficiaries in the trust. So my children, A, B, and C, can be in the trust, and it can be elaborate, like I mentioned. So I could say something like, I'll give you a hypothetical situation. Person's worth $3 million and have 3 children, A, B, and C. And you say, upon my passing, I want my child A to get $1 million outright. Child B, I want that child to get $1 million, but to be held in trust for the benefit of B. And why would you do that? Well, perhaps B has a drug habit, or maybe not even anything bad, but they have a disagreeable spouse, or they have marital discord, or B likes marijuana, or B is a gambler or a spendthrift, or likes to use the money, and we'll go through that money quickly. So you can place the money earmarked for B into a trust. And C, child C, you may say, I'd like child C to get that $1 million as $100,000 for a period of 10 years. A got it outright, B got it into trust, and C got it spread out over 10 years. And that's a completely, it's a fictional story, but an actual method that people can use, that you can use for your family. And that's the instructions or directions that the grantor can place into the trust to have the trustee follow. Your age, your circumstances will determine what you want to do. So a revocable living trust, right, with an R, a revocable or revocable, the name would imply you can revoke that trust, you can change terms, and you can be your own trustee. This document will avoid probate because it's recognized as a separate legal entity, separate and apart from you. When you properly create a trust and then properly fund or retitle assets into the trust, the living trust owns the property. You don't own it. Therefore, the assets in the trust avoid probate. They bypass, and you have to do that properly. A properly funded trust avoids probate. That's an often critical and too often overlooked item. Additional benefits. So I kind of said these, but let me drive it home. Provide discretionary distributions to children. So you could say, in my example of A, B, and C, you could say, so B and C, B got the money in a trust for their benefit, and C got a payout over 10 years. During that period of time, you could say, in the event that B, the grandchildren of B, attend college, I want to give them the sum of $1,000 or $22,000. Or any number. And you could do the same for C because money was being held for them. Now, you couldn't do that for A because you gave that money outright. However, you could do that during your life. You could say for any milestone event, graduating college, opening a business, buying a house, you could put into the trust these milestone events and give these discretionary distributions. You could protect your adult children from their spouses. You could preserve capital for a future generation, keeping the money for B in a trust. You could provide in the event that B or C have special needs children, you could provide for that. And you could direct and protect from the grave. So upon your passing, you can impact your family far, far into the future. You might want to consider a living trust if you own a home or a property, because you take the house and you put it into the trust. You can live there for the entirety of your life. And upon your passing, whoever's going to receive that as a benefit, as a beneficiary, will receive it with a stepped up basis. That's an accounting term and is very important in real property. A stepped up basis causes you to be able to sell, causes your beneficiary to be able to receive and sell a property without paying a capital gain. You want to pass your estate to your heirs with little delay or no expense. Do we avoid probate and the length of time and the cost? You want your affairs to be managed in a very specific way, even if you're incapacitated. And you want your affairs to be private. A trust is a private document, never required to be filed anywhere and not filed with the court. So what's the third threat? Lawsuits of a business nature or a personal nature. Someone slips and falls on your property, a contract isn't adhered to, and it becomes a contract dispute. In the unfortunate event of a car accident or a wrongful death proceeding, all of your assets in the trust, an irrevocable trust, are protected. And so these lawsuits and litigation would affect you, but it also would affect your family members if you passed away while in the middle of a lawsuit. So your own predators, your own threats to your family security could be your family, bad luck, your child getting into an accident, irresponsibility, right? The child A that received $1 million, what if they spend it all? What if they blow it? Well, what if they mix their money or mix their money? I want to say they transmute it. That's a matrimonial term. But they could take the asset that was to be their inheritance, place it into their own joint account with their wife or husband, and that money could be lost, or a portion of it could be lost in a future matrimonial action. If you put that money into trust, like in our example of child B, that would protect you from a bad spouse. So not knowing your creditors. So this is an example of an unintentional disinheritance. So in this example, Bob and Sue are married and they have children. Unfortunately, Sue passes away. Bob's living in the home with his children. Children grow up, kids move. Bob remarries. Bob marries Sylvia. He is deeply in love. And what Bob does, he places Sylvia's name as a joint owner of the property. And unfortunately, Bob passes away. Who owns the home now? Sylvia. And Sylvia is not the parent of Bob's kids. And Sylvia does not provide for Bob's kids. Now, you have to believe that Bob wanted to protect Sylvia and have her live and reside in that home for all of her life in the event that he passed away first. But I bet you Bob did not want to disinherit his children. Now, if he did, he did. But I don't think, in my example, Bob wanted to protect his children. But we could have done this with a trust. With proper estate plan, you can protect your estate from estate taxes. There are two estate taxes, federal and New York state. So with our current tax laws, most Americans don't have to pay federal estate taxes because the tax only applies if you have individually more than $11.5 million. And New York State, unfortunately, has high income taxes and they have high real property taxes, but New York State, fortunately, has favorable estate tax rate. So you get nearly $6 million and not have to pay estate tax, New York state estate tax. So long-term care is a predator. This predator is this outside force that's attacking your assets and what you have. The long-term care is defined as care that is provided on an ongoing basis, a regular basis for 3 or more months. Home care, an aid in the home, care in an assisted living facility, or in a nursing home. So long-term care costs can be expensive and it can eat up your savings rather quickly. I have people that are prospective clients and then persons that become actual clients. They're in a bad state. They get, typically this is adult children that come to me when their parents is in the hospital and moving into like a facility, assisted living facility or a skilled level nursing facility, and they have money in the bank and no proper planning, and they want to know how they can save some money while also providing a government benefits for the benefit of the parent. And there are certain legal maneuvers we can take, but it's always best, and you save the most when you pre-plan and plan in advance. So we get older and infirm, and we should anticipate poor health. We really should, right? We should think about that and plan for it. But when it happens, it's never really expected. My mother's 83 and she was perfect until last month. And there's no plan. That she's 83. Think about that. Or my father's 78 and now he needs skilled level care. Yeah, think about it. Now, if the 78-year-old planned, when they become an 83-year-old and needs planning and have a need for planning, we have it covered. Plan when you can. Stroke, dementia. We learned, I'm asserting, I don't know how much you really learned. We learned that long-term care is costly. We all have in us the possibility of stroke, dementia, Parkinson's, Alzheimer's, with the cost of care being 5 to 14,000 to maybe even a little more, we need to pre-plan. Every 3 seconds, someone globally is diagnosed with dementia. Every 3 seconds. How do you pay? There's only 3 ways to pay. The very rich can privately pay. The very poor can qualify for government benefits, Medicaid. You can pay out of savings. If you're middle class and you've saved all your life, you can pay with your savings. If you had long-term care insurance, that would cover. And if you don't have savings, if you don't have insurance, if you don't have a lot of money, you can qualify for Medicaid. But there are strict asset and resources, the Medicaid word for income, asset and resource eligibility requirements. How do you know if you qualify? Well, every case is different. We can assist you with analysis or assist you in pre-planning for your future needs. It's not so simple. There are a lot of issues. And one thing to learn about Medicaid is that I'll give you a few things to learn. It's a federal program administered by the state. So New York administers Medicaid differently than New Jersey, differently than Arizona. And it's a welfare program for the poor. The poor is in quotation marks because it's poor as defined by Medicaid. So you could own a home, you could have some thousands of dollars, but it provides assistance for community or nursing home Medicaid. Medicaid has strict and confusing guidelines as to who can qualify for assistance. Each state differs, but overall, you must be at least age 65 or be blind or be disabled. And you have to have countable, that's language of the Medicaid, countable assets in the poor range. So for a nursing home, it's about $2,000, and they vary from year to year. And the applicant's spouse, you can have assets, maybe about 100,000. But again, it's something we need to speak about and to look at all of your financial assets, where they're situated, and what you're attempting to do. Some people want the government to pay for long-term care, so they don't have to use their life savings. And when possible, we want that also. This way you can pass your assets on, or at least a maximum amount allowed to your family. And for those folks, Medicaid planning, that's an option. We plan now for a possible future use. It's advanced planning to ensure that you qualify for long-term care when it's needed. So consider an irrevocable trust if you want asset protection and long-term. Good news and bad news. We're living longer. And there's some gallows humor here. I don't mean to laugh or joke, but we used to live and die, and we still live and die, but we used to live and die quickly. Heart attack, stroke. Now medical science is advanced, so they keep us alive, but dependent on others in an infirm, disabled condition. Half of everyone age 65 or older, half of those people will need long-term care. Do you have children that can take you in? I have many children that say many adult children that say they can't take care of their parents. Sometimes it's because of space, or it's because of the debilitating nature. You have to get a parent out of bed, to the bathroom, in the shower, out of the shower, back to bed, in a wheelchair. What about if the person is a larger person, or heavy set, or big bone, or just a big person, and the adult child cannot lift their parent? How do you do that? How do you take care of it? We want to plan when we can, as opposed to when you can't. So there are 2 different types of plan: vertical and horizontal. Vertical planning is planning when you're alive and well, have full capacity. Horizontal planning is not when you're in the grave, but when you're on your back in a bed. You deal with both, but there's 2 different results. Pre-planning can save everything. And planning when it's too late, you either have the option of not being able to plan at all because the person has no capacity and no proper documents in place, or you lose a significant portion because of the rules of Medicaid. A general attorney will not have the experience to know what to take into account. The general attorney may have taken an estate plan, in a wills class or an estate class in law school. Maybe they take a class here or there. But why should you use me? Well, I study this subject on an ongoing basis. I give public webinars. I'm a member of a number of organizations. I go to continuing legal education credits. I go to conferences. Pre-COVID, I used to go to other states. I haven't gone anywhere since the quarantining, but I have attended online webinars in my field. So these are some organizations that I'm a member of: New York State organizations, New York State Bar, the Queens County Bar. Matter of fact, In 2021, I was the president of the Queens County Bar. I'm still active in these committees. And I think it helps me because I have hundreds of colleagues that I could, we do two things. I answer many questions for my colleagues, and my colleagues answer many questions for me, right? We can speak to the topics and the issues related to elder law, guardianship, estate planning, and how to properly protect assets. And I speak about this on a daily, weekly basis. And these are my national associations that I'm a member of. All of these national organizations have listservs, and I'm up to speed on learning the latest trend. And why is that important? Well, Medicaid, as I mentioned, is federal. So I'll see the trend in California or Florida, which is very important because California and Florida, in many ways, are a similar enough animal to New York that I get to see the trend and all, not knowing the real costs. Unlike any other area, estate planning has monetary costs and also personal costs. For some family members, it's ignored, and sometimes ignored too long, and sometimes until it's too late, and sometimes just enough time. So get ahead of yourself. Failing to plan is the problem, and failing to plan correctly is the problem. Standard documents, when they're not appropriate for your situation, is a problem. Planning ahead with personalized documents, it's the way to go. I can assist you with that. Move money here, move money there, change this designation, use this type of trust. That's what I'd like you to do. I joke around. You could buy a scalpel, you could buy a white coat, you could don a KN95 mask. It doesn't make you a surgeon. You need the technical knowledge behind the documents to make the plan correct. I anticipate your needs and I discuss with you your possible needs. We discuss the threats. How do we avoid it? Well, I offer different types of plans. There's a will-based estate plan. This may satisfy your needs. It may satisfy your financial investment is all you want to pay for, and it could be appropriate. We'll talk about it. And there are two types of trust plans: a revocable trust plan, the will, the healthcare proxy, the power of attorney, and the revocable living trust, and the irrevocable trust, everything that's above it, plus an irrevocable trust that protects your assets. You could call it an irrevocable living trust, or a Medicaid asset protection trust, or an irrevocable grantor trust. Those are just terms of art. The key distinction is revocable, where you're the trustee, or irrevocable, where someone else is the trustee and giving you asset protection. This is my free advice. Avoid bargains when purchasing parachutes, scuba gear, and estate plan. We have a range when appropriate, when I can, and you would know early on in the process. I give a fixed price legal fee. For a single person, a will, $500. For a married couple, $900. I give you two separate wills. If you want sweetheart wills, if I die, everything to my wife. If I die, everything to my husband. And then it passes. So that could be a sweetheart will. I give you two of those. The estate plan, will, power of attorney, healthcare proxy, living will. That's both the document necessary to pass on assets at your passing and documents for during life. These are the advance directives that are significant and important to have. Revocable trust plan, and I tailor this to you. Single person, $2,500. A married couple, $3,800. For a married couple, we do one joint trust. It's a great way to go, perfectly acceptable. And I give both of both husband and wife, they get their own will, their own power of attorney, their own healthcare proxy, and their own living will. And then the irrevocable plan. We replace the revocable trust with the stronger asset protection irrevocable trust. That's really where I am on fees. Next step, consultation on the phone. Schedule 15-minute call. If you have any questions, when I have time, I speak for longer than 15 minutes. No guarantee, because sometimes I need to get off. But if you have any questions, you'll have my email. We can correspond. You can even schedule another appointment. And the relationship, the window of time is once you sign up and fill in an intake form, we do our best in all of the cases to schedule the signature meeting, right? The execution of those documents, whether that be in 3 weeks or a month or 5 weeks, depending on what's going on in my work life. So if you sign up today, conceivably, and you pay and you sign an intake form and we start our attorney-client relationship, conceivably 3 weeks from now, we can give you an appointment to come into the office to sign your documents. And that's it. And we're done. But schedule an appointment to discuss if you have any personal questions. If you have a trust, if you have an estate plan, you want me to review it, of course, I'll review your plan. It could very well be you have a perfect plan. It could also be that it needs to be updated. We can review it together. I'll see if there are any questions. Erin had given me a question earlier, and it was, could you describe the difference between an irrevocable trust and a revocable trust? And I did speak about both, so hopefully I gave you a good sense of what those differences are. And they're very similar in that they both avoid probate. They both avoid delay. And they both avoid multi-state probate. How are they different? A revocable trust, the grantor can also be the trustee, and it does not provide present-day asset protection. Any asset that you have inside of the revocable trust is exposed for Medicaid purposes, and the irrevocable trust provides asset protection. Let's see. I received the question, and it's, what if a married spouse has a drug problem? So it depends on the nature of the asset. So if your spouse is a joint holder on your savings account, well, they can access it. So let me give it from a couple of different perspectives. If a person has a spouse that has a drug problem, you should do your best. And if you're still married with that person, because we're both alive, so that's not necessarily an estate planning question, but I will discuss it if it's your adult child. If I had a spouse that had a drug problem, I would do my best to remove that person from bank accounts, from credit cards, from the ability to access money. And you're doing it for their benefit. So if I had a joint bank account with Chase, I'd go into that bank account, I'd withdraw all of the money from the account, and I'd open up a new bank account in my name alone. It didn't become your money 100%. You're still, under the laws of matrimonial laws, it's complicated. You're basically, if you're ever going to get divorced, only entitled to 50% of that. Under the laws of banking, there might be the presumption that you own 100% of it. So there's the combativeness of the different areas of practice. But the reason I say take that money out, put it into a new bank account in your name only, is so that your spouse can't access it. Now, if you opened up a trust, an irrevocable trust, and took the asset and put it into the irrevocable trust, no one could touch it. Creditors, credit cards, no one could touch it. It doesn't mean that if you were getting divorced, that you might not have to give back 50%. Now, if I was going to leave, remember my example, A, B, and C, my own child B, $1 million in trust, I would have that for child B only in their individual name, only for their benefit. And then the trustee could dole out money, distribute money to child B as child B requests, and would never give it to the spouse of B. I hope I answered that question. I've received a question. If property is retitled into a living revocable trust, will the lender allow me to pull out money, cash out refund? There's a short answer and a longer answer. Yes. It is legally permissible. That's the short answer. A lender will allow you to pull out money. However, there are a fewer amount of lenders that are willing to lend on a trust. Because the trust is such a protected vehicle, banks are some banks are somewhat hesitant to lend money. A useful feature might be if you were going to retitle your asset into a revocable living trust or an irrevocable living trust, you might want to refinance the property first, secure a mortgage in your individual name, create a trust at the same time, and then retitle the property. The mortgage will not be called in because there's a federal law that permits you to it permits you to borrow money and not call the loan. There's no due on transfer sale. It's the St. Garment federal law. Okay. If you have any other questions, put it into, okay. So the question was, can a non-beneficiary contest the two trusts? Conceivably, that type of litigation is possible, but very difficult and nearly impossible. So I'll give you an example. If I have a spouse and 3 children, and I leave to my 3 children, there's who's the non-beneficiary? Someone come in? No. I guess your question would be, I have three children, A, B, and C. I only provide for A and B. Can child C come in and attack that trust? Theoretically, they can, but they would have to demonstrate. It's a significant bar and a barrier to C coming in. Why? It's just the same way while I'm alive and well and I have full capacity, what if I just gave my house away? What if I sold my house and don't provide for child C? I sold my house and then give money to A and B. I'm giving crazy examples just to drive the point home. C would not have standing to come in and contest something that I did during my life. So by the very same token, a non-beneficiary child will have an uphill battle to try to demonstrate that I didn't have capacity and I shouldn't have placed my assets into the trust. Really, really very difficult. And that's the benefit of a trust. It's a private document. That child C won't even know that it didn't provide for them. So they won't know to contest it. And then when they do attempt to contest it, very difficult. Properties that are in an LLC, your shares owned in the LLC or in a regular S corporation can be placed into a trust. The trust can own those shares of stock. Just the same way you might have a stock or bond or Vanguard funds or Fidelity Mutual, you can retitle those into the name of the trust. The very same way, if you owned IBM or Apple or Amazon or any other stock, you can own that in the individual trust. See if I can have questions. If there are any questions, please reach out. I'll do my best to answer. If you have a fact-specific question, these questions were great, by the way. It allowed me to speak a little bit on the topic. If you have any questions that are fact-specific, it would be best to schedule an appointment. I can address your individual life circumstances. All right. Thank you. Thank you all for attending. I really appreciate it. I appreciate the questions. And be well. Stay safe out there.
Good afternoon. Thank you for joining me on this webinar today, the guardianship process from incapacity to court appointment. This is a little bit about me. I am in private practice in Queens, New York since 1997. I graduated law school in 95. I worked for another lawyer. I opened up my own practice and I've been here in Glendale ever since. I serve the greater Queens and New York City area. This is my staff. Josephine will help me in all things elder law. Aida handles issues related to probate, and she works most closely with my associate, so she'll handle issues related to evictions and divorce as well. There's a snapshot of the organizations, the associations that I belong to that are New York State specific. The New York State Bar Association, the chapter of the National Association of Elder Law Attorneys, and the Queens County Bar. I am actually going to be the president of the Queens County Bar in June of 2021. So this year, in a few months, I will become president. I have been the chairperson of a number of committees, the Family Court Committee, Bar Panels Committee for the New York State Bar, the Office of Court Administration. I'm also a member of the Character and Fitness Committee. A little bit about me. Now, I want to show you some national organizations that I belong to because the field of elder law is handled differently in all of the states. And belonging to national organizations, I get to see the trends. These are some very good associations with very fine people that really, they help me, I help them. I'm a member of these listservs, and I'll field and answer questions on behalf of other attorneys, and I'll get some of my questions answered as well. So it's good to have that collegiality. The topic of the day, what is guardianship? So there are several areas of law in New York that are called guardianship. There is a family court guardianship where a person that will become involved in the family, sort of like a parent analog, perhaps a grandmother, an aunt or an uncle, because the parents aren't able to take care of the minor children, and they'll seek court permission to be the guardian. I've done that a number of times, sometimes in the context of parent having passed away, and I've represented grandmothers or siblings of the deceased parent, really quite a lot of times in the family court. That guardian is the caretaker of the child for medical reasons. doctor's visits, enrollment in school, enrollment in health insurance, parent-teacher conferences. That's the type of guardian. That guardianship has nothing to do with money, and you can't become the guardian of the money of the child should that child have inherited money. That's in another court. Handling money for a child, besides the person of the child, can take place either in Supreme Court, in an Article 81 proceeding, or surrogates court, also in a guardianship proceeding. So guardianship generally is a legal arrangement where the court gives permission for one person to have the legal right to make decisions for another person. So if there's a child that's 16 or 17 or 2 or 3 years old, right, that child can't make decisions. The court gives the permission and authority to someone else. Now, that's for a child because a child has an incapacity based upon age. They have a disability based upon age. Right? They can't contract. They can't sign things. They could affix their signature, right? But a child can't sell property. A child can't enroll themselves in school. So that's farmed out to this adult guardian. But similarly, an adult that has dementia or Parkinson's or Alzheimer's or the victim of an assault or an attack or even a disability based upon a stroke or a mental incapacity because of special needs, that incapacitated adult also needs a guardian. So whether a person is an incapacitated adult, they had formerly had capacity. Me, I'm young, healthy, I'm robust, I can think for myself, but pending a tragic accident or the onset of dementia, I can't make decisions for myself any longer. Well, then I would need one of my adult children to come in and be my guardian, or I'd need my spouse to become my guardian, or a brother or sister to become my guardian. And finally, the third class of person that might need a guardian is a child that's developmentally disabled that becomes an adult. And the child is a child at 17 and they're an adult at 18. The magical transformation happens with the turn of a calendar. That person might need their parent to be the legal guardian. So the types, what are they and when are they needed? So for a minor child, there's the absence of a parent, the death of a parent. The parent is unavailable, unable, perhaps based on a physical condition, maybe their own developmentally disabled situation. Maybe they're working abroad or they're working in California on a pipeline. I don't know if we have oil pipelines anymore. Maybe up north. I think they're going the way of the dinosaur. The guardian is like a parent. They serve in that parental role. I'll also mention guardian ad litem. This is a term that's used in a number of different courts as well. So if you have a developmentally disabled adult or a person that might not have an understanding of the court process or what's going on, the court looks at a list of attorneys that are qualified and competent in that area of the law, and the court will appoint an attorney guardian ad litem. I myself am on the list of attorneys that gets appointed. This week I was appointed to 2 cases. One from the Manhattan surrogate, and a child is going to be inheriting money as a 16-year-old. Unfortunately, their parent is deceased. They're inheriting money, and I am appointed to look out for the interests of that 16-year-old child. I was also appointed to a case where the actual other situation doesn't involve a minor. It was unknown persons. But I have been appointed in family court to become a guardian ad litem for a person in several different areas. They were facing a family offense, and they had a lawyer. The court also appointed me so that I could assist in their defense. I've been the guardian ad litem for a child in juvenile delinquency proceedings in the past. The parent doesn't show up. Sometimes the child is arrested. The parent is unavailable. They assign a lawyer for the child, and then someone, an attorney or from a list, is appointed to act in that instance really as the parent for the child and help them to interpret the law. And presently, I am in the middle of a case where a divorce was going on, and the divorce judge observed that the litigant, the husband litigant in the case, did not seem quite aware of his surroundings and the situation, and that court proceeding was stopped. It was halted. That judge appointed someone to prosecute a guardianship proceeding, and as a result of that guardianship proceeding, I was appointed to be the special guardian for this gentleman in his divorce because I do happen to know elder law. I happen to be qualified to be a guardian. I have a number of roles that I could play, and I do have a deep understanding of divorce law. So here I am as the special guardian for this gentleman going through a divorce. And we put a lot of words on the slide so that I could give some information and that you could read the slide to supplement what I'm saying. So these are the reasons that you might have a guardianship for an incapacitated adult, a disability, a mental illness. The person can't care for themselves, say someone with dementia or Alzheimer's. Maybe they want to turn the stove on. Maybe they want to wander outside their house. That's why you might do a guardianship. Not exactly in the law, but the guardian can function quite like a parent or have a parental role, even for an adult person. And this type of guardianship, which is going to be the focus of today really, is handled in the Supreme Court under Article 81, and the area of law is the mental hygiene law that governs disability of adults. So the guardianship is a court process, and I have some slides on that, but one person files, a person or an organization or a hospital files, and they allege, they say, hey, this person is does not have capacity. They're not quite there. There are some circumstances that we've observed, and we think that they need a guardian. I've seen this situation happen where a person was in a hospital. A typical scenario is an elderly person in their home or apartment alone, and they fall, they pass out, but they fall to the floor. They cannot get up. They become dehydrated. The mail piles up. A neighbor realizes that they haven't been in communication with them. The phone isn't answered. 911 is called. The police show up. The person is removed from their apartment, brought to the hospital. At that point in time, due to dehydration and their circumstance, they're probably not coherent. The hospital may file for a guardianship at that point because no one came to visit, no one claimed the person, they have no information how to get paid. That's a reality for the hospital. And maybe they need to bring the person back into the community because they're of a stable nature and they could be released back, but they would need a guardian to do so. Let me go through who the players are in a guardianship. The petitioner is either the person, the adult child, or the spouse, or the hospital that identifies that the person needs assistance. I have some slides on a few of these. The petitioning attorney would be the person that either represents the adult spouse, the adult child, or the hospital. A court evaluator is a person that's appointed by the court to be the eyes and ears of the court. If the alleged incapacitated person has some awareness and they say, I need a lawyer will be appointed to them. There's a geriatric care manager. That's a person that will assist in the coordination of services. There's a court-appointed guardian at the conclusion of the hearing. If the petitioner prevails, a court-appointed guardian will be appointed, and that could either be from a list or there could be a nominated guardian. That's where the petitioning attorney puts forth a name. Something like, I represent the spouse would like to be the guardian. The court could choose to pick that spouse, or the court could pick and appoint an attorney from the list. And then a court examiner, that's a specific role on an annual basis, and I'll explain a little more later. The guardian, at the conclusion of the hearing, should the petitioner prevail, the court will choose to appoint a guardian for either the person or the property, or both. The property is a term of art. It doesn't necessarily mean that a person needs real property, a house or a building. It just means that they have property such as a bank account or a house. More than likely, if you have a criminal record, you will not be able to be a guardian. If it was remote in time, I have seen instances where an adult spouse that had a 20-year-old criminal record was made a guardian. But more than likely, if you had any kind of criminal case within the last 10 years and you were convicted, probably not, but we can talk about specifics. Guardian of the person makes life decisions for the ward, healthcare, education, welfare decisions, enrollment in programs, deciding whether they live in the community or in a residential home or in a nursing home or in a rehabilitation center. Sometimes the guardian is given that permission. Sometimes the guardian has to make a new application and say, Judge, the person was living in the community, but now their condition has deteriorated. They really do need to be in a skilled level nursing facility. Guardian of the property handles the money, takes care of all of the income, Social Security, pensions, retirement, gathers that up, marshals the different bank accounts, opens up a new bank account, and then spends the money on behalf of the guardian. It could be the same person, or it could be two different people. Sometimes the court will bifurcate the roles. and make the adult spouse the guardian of the person, and an attorney from the list the guardian of the property. Depending if the person is sophisticated, they have knowledge of how to save and invest the resources of the person. The ward. So a person goes from being an alleged incapacitated person at the outset of the case to if they win, if they prevail, maybe they really aren't incapacitated. They had a momentary lapse. They were in a coma for a period of time, but they awoke in a very alert cognitive state. So either they become an incapacitated person if the petitioner prevails, or they just remain a regular citizen if the petitioner does not prevail. If they become an IP, another word for that is the ward. That's the person that the guardian makes decisions for. This is actually a court case, so the petitioning attorney has to put on witnesses and evidence. The court evaluator will testify. They write a report and they'll testify at a hearing. It's a trial. It's a trial before a Supreme Court judge. And along the way, if the person consents to a guardianship, they would not be titled an incapacitated person, IP. They would be titled a person in need of guardianship. It's a PING, P-I-N-G, and it's a term of art based on a consent finding. So when a case is brought, the court issues a court date, and this will issue an order directing the appointment of a court evaluator. I have been that role. You have to interview the petitioner, go to the home of the alleged incapacitated person, take a look in their refrigerator, take a look at their windows, take a look at their prescription list, maybe speak to a doctor or a nurse, take a look at their finances, and then you write a report. And ultimately, it's the responsibility of the court evaluator to be the eyes and ears of the court, to write a report, do investigation, and then testify in court. And then the recommendation is something like, based upon my interview, my investigation, my 21-page report that I'm submitting to you, I believe that this alleged incapacitated person actually does need a guardian. And then the court just takes that under advisement. The hearing is still conducted, and other new, different evidence could come into play, notwithstanding the recommendation of the court evaluator. If the alleged incapacitated person has some awareness, maybe it's a close call, maybe they really have moments of lucidity. If they say, I'd like an attorney, the court will appoint them an attorney prior to the next court date. They would participate in conferences. They would meet and prepare with their client. I have been the attorney for an AIP. I've participated in these hearings. I have also been appointed as an attorney for an IP. So sometimes these guardianship appointments only last for a year. The court will say, I think this person does need a guardian. The term of the guardianship shall be for 1 year. And sometimes at about 7 or 8 months into the guardianship, I will be appointed to the incapacitated person because the guardian has filed a motion to extend the guardianship. And then I have to meet with the person and either obtain their consent or participate in a hearing. I have a person now that I was appointed to about 2 months ago. And we've spoken on the phone. We met by Zoom, and the gentleman does want a meeting with me, so we're going to meet in person. It'll be our first in-person meeting. But I have spoken to him a number of times, and I did participate in a conference for him. And the issues are for this is that this gentleman would like to be returned to the community. He's in a nursing home, and he is of sufficient ability to go into the community, and he might even be willing to consent to the guardianship for another year, provided we get assistance in locating an apartment. So we're navigating the issues related to that. Court-appointed guardian is someone from a list. Most often it's an attorney. There are some social workers on the list as well. And then a court examiner. One of the obligations of the court-appointed guardian is to annually file a report. The court examiner has to make sure that that report is filed both with the court and then with the court-appointed court examiner for the case. And then the court examiner must examine the annual accounting and write a report. I actually am a court examiner for Queens Supreme Court, and I have a number of cases on my inventory, and annually I receive reports and I review those reports on behalf of the court. There's about 30 of us in Queens, maybe a little less. Sometimes it's in flux. I've been a court examiner since 2010. And what happens is there are just too many cases. There are thousands of people that have to file annual accountings, and it's too much for the court to review. So they parcel these cases out to attorneys in the community that have taken continuing legal education classes in this field, and by legal skill, acumen, practice background, and credits, has the sufficient knowledge to review these annual reports. Who can commence a guardianship proceeding? Well, you have to look at the law, and Article 81, 81.06 directs that a guardianship proceeding can be commenced by the AIP, the next of kin of the AIP, an executor or administrator when the AIP is the beneficiary of an estate, the trustee of a trust when the AIP is the beneficiary of the trust. So I have money that I want, I'm the trustee, there's money that's going to be or can be distributed to the alleged incapacitated person. This person, right? All people are either regular citizens, because there's no court case, or if you see you have that person that maybe they're not quite responding correctly, say I have to give that person money as the trustee, I'm going to think twice and I might start an action so that we can have the court intervene and take a look at this. So a facility where the person is, like a hospital, sometimes even a nursing home, and sometimes it's needed to be done for a medical procedure. So there might be a person that was not incapacitated. They were just physically, physically they weren't strong enough to live at home on their own. Maybe they had mobility issues or transitioning issues or issues on how to cook or feed themselves, right? Hard for them to shop. So for any one of a number of reasons, they went into a nursing home, but they were mentally sharp. Should they become incapacitated along the way, maybe lose their mental faculties, the nursing home could file as the petitioner for a guardianship. They most often won't do that unless the person needs a medical procedure, right? Or if their money isn't being properly cared for. So everything is fact specific. So the petitioner gathers up information and has to do an order to show cause and an affidavit. This affidavit has to have merit. It has to be based on certain facts. Hey, I'm coming in to be the guardian for my uncle. He's living alone. I think he has dementia. He doesn't always remember his siblings or me. He doesn't always remember things. He orders from the internet. He has too many boxes in his home. He likes to hoard things. And I'm really scared because I've been to his home and he's left a flame on. Or in the middle of the night, he wanders out. Or he still is driving a car and I'm concerned that he's on the streets. So for any of those type of reasons, a petitioner will come in with this petition. And then the court will direct the court date. They'll appoint a court evaluator. And sometimes a person will come in and seek immediate relief. My uncle is 82 years old and he's wandering out at night. He's still driving. And I know I really have a reason to believe he's a danger on the road. I think I'd like to be his guardian. And also, court, please give me permission to take the car off the road immediately before we have the hearing. The court might not always do that. But if you've supplied credible evidence, maybe the person had gotten a ticket, maybe you have one or two witnesses that have seen that, you yourself have observed the person in a car, maybe the court would take the ability for that person to drive away, at least temporarily, maybe a 2-week period, a 3-week period until court is started. On the first date, it's typically a conference. All of the participants will give their position. We'll speak about the case. We'll discuss the merits. And then ultimately it will get scheduled for a trial. Witnesses and evidence have to be produced. The court evaluator will be a witness. Usually the petitioner or an agent of the petitioner will testify. Sometimes we have doctors, nurses, psychiatrists, or social workers testify. Sometimes these are 2 witness cases, sometimes 4 witness cases. And it also depends if these cases are contested. Cases can be contested really in 2 different ways. So one of which is the alleged incapacitated person contests themselves. They say, I'm not incapacitated. I have my faculties. I know what I'm doing. And they either go out and hire a lawyer or they get appointed a lawyer. And that's rare, but it does happen. I've seen cases where the adult children and the ex-wife have really coalesced as one team against the father, ex-husband, and his new wife. Right? They've alleged that the ex-wife has the person under this spell, and it's because they have an infirmity. And that's a situation where they're contesting whether or not the person has capacity. The other type of contest that I see, this is with greater frequency, is where everyone agrees that the person has some level of incapacity. We'll see adult children fighting the new spouse, or adult siblings fighting over their parent, where they say, hey, mom, dad needs a guardian, but that guardian shouldn't be you. The guardian should be me. And they allege some reason for that. So that's the other way it could be contested. And, when a situation is uncontested, that might be the 2 witness case. And when there's a significant contest, that might be the 4 or 6 witness case. If the judge determines that the AIP is in fact an incapacitated person, they'll issue an order in judgment. And the order in judgment specifies the rules and regulations, the guide path of what the guardian can do. So marshal all bank accounts, keep the person in the community, prevent the person from being evicted, take a look at whether or not the person needs Medicaid planning. The guardian may be required to post a bond. So a guardian is a fiduciary, and if they're entrusted to the guardian to be the guardian of the property, the court might order that person to get a bond. So the bond is an insurance policy. Even if the guardian did something terrible and ran away with the money, the person would still be, we'd hunt them down and convict that person, right, through the district attorney's office. But the bond would secure that the person, the incapacitated person, was not harmed. And there's a mathematic formula, the assets of the person plus 2 years of income. Small estates, 20,000, 2,000, 18,000, the judge is probably going to waive a bond. After the hearing, there's a person with the title proposed guardian. And that guardian has to take certain tasks. They have to file a consent to act, an oath, and designation. They have to get a commission. And they must file the commission in 90 days, and they must attend the class, and they have to do an initial report. All guardians are required to take this class. It's offered through the Guardianship Network. There are other associations that offer it. The guardian must attend this class, and it tells them what their obligations are: to file a report, to marshal assets, to visit their ward at least 4 times a year. Within 90 days of getting the commission, becoming commissioned, the guardian has to file an initial report. And that's really a snapshot of the financial issues. You put down the name of the doctor, the dentist, the eye doctor, right? So some issues related to their physical well-being. And then you might say, I know the person has a pension with the, to the tune of $740 a month, and Social Security for $952 a month. And that report gets filed with the court, and it also gets submitted to the court-appointed court examiner in the case. Every year, the guardian is obligated to file an annual report. Just like you file annual taxes by April 15th, an annual report is due by May 31. In COVID, it was extended just a couple of months. For calendar year 2020, the annual report is due May 31 of 2021. Just like the tax return being due April 15th is for January 1 to 12/31 of the year before. A guardian gets paid, they can get compensated. The primary way is to be based on the assets of the IP, the incapacitated person. So a person that has $5 million in assets, that guardian will have a higher annual compensation than a person that's the guardian for someone with only 20,000. And the theory behind that is everything is heightened when you have more money. As a fiduciary, you're responsible for safeguarding that money, making sure it's in the right investment vehicle, being in touch with the brokerage accounts, making sure the money is handled wisely, conservatively. Sometimes the guardian is a family member. So maybe if it's a spouse or adult child, they might waive the compensation, but it's not a requirement. If the incapacitated person has real property, a house, a building, a co-op, the guardian has to apply through a motion for the permission to sell that. I've had to do this on behalf of a guardian in the past. So I've been appointed a guardian, at least one example, I've been appointed a guardian where the person was already in a nursing home. Then they applied for a guardianship. The court appointed me. They had a home in the community. It was a 2-family home. I had to get permission to sell the home, permission to evict the tenant, permission to conduct an auction, and ultimately permission to attend the closing and act on behalf of my ward. I was the guardian. So in selling a real piece of real property, you need to ascertain the value. The court will appoint an appraiser. They'll appoint a court-appointed real estate agent, and that's it. So if the person has a substantial sum of money and they cannot qualify, and look, even if they have 35,000 or 40,000 or 80,000 or some sum of money, that's going to prevent them from being able to secure Medicaid. And the guardian can request permission to do Medicaid planning and asset protection. So that's explored. The court will definitely say, hey, explore that, because they don't want to waste the incapacitated person's money, and they want to maximize that person's money for their longevity. So I'm segueing to one slide on estate planning. This is the process of organizing and arranging an individual's assets during their lifetime for their own use and benefit, and then to minimize the tax consequence, gift tax consequence of distributing that money to the next generation. So sometimes I say 3 W's and an H: who, what, when, and how. How will your estate be managed in the event of your incapacity or death? So in the type of guardianship that I've been mentioning, this is really an incapacity during life. Let me hold that thought and explain it on the next slide. What is elder law? Elder law is an area of practice that deals with this senior population. And I am an elder law estate planning focused attorney, an elder law focused estate planning attorney. Let's say it that way. So in the old days, and even today, if a person lives and dies quickly, a will is fine, right? Depending on how complex their estate is. That doesn't happen to people anymore. They live, we all live, and then we ultimately all die, because no one's getting out of here alive. But they die slowly. That's really the typical scenario. And if you have an incapacity during your life, you use up the bulk of your money and your estate. And listen, if the person needs to use their money and they want to use their money, more power to them. What I'd like to do is maximize their money so they can use their money for what they need, secure government benefits for what they can, and then pass along the most money to their heirs. So in a guardianship, hey, does it ever end? Well, some are of a indefinite duration. This person is the guardian for all time. That's obviously subject to future court decisions. Sometimes the court will say, hey, I'm going to make you the guardian, but for a specified duration of time. Sometimes it's 1 year. Sometimes it's 2 years. And I've had a number of those cases, and the person was in a coma, then they came out of a coma. The person had that temporary disorientation based on being dehydrated and having fallen. And within a couple of months, even a couple of weeks, really, they're much better. The guardianship also has to be terminated when the incapacitated person passes away. Sometimes we end a guardianship in New York, but only after we've started a guardianship in another state. I've dealt with Nevada, with Florida, with California. Why? Because a guardianship was prosecuted here, and then one of the adult children lives elsewhere, and they want to move the parent closer to their residence. Well, the court, if the guardianship is still needed, the court won't just terminate that guardianship. The court in New York will want a new guardianship to be established in that county of that state, and then all of the sums of money and this matter will be transferred to the other jurisdiction's guardianship. So that sometimes there are guardians that just resign. I recently had a situation where an attorney, after a long and quite marvelous legal practice, retired. She was really a very good attorney, a very good guardian. She was also a court examiner. I think she was a lawyer, 40-something years. Her husband retired 2 years ago. She kept working in this field, and then now she just retired. So a new guardian has to be appointed, or in some of the cases where she was court examiner, a new court examiner has to be appointed. Now, sometimes the court will revisit that situation. Hey, is this person remaining developmentally disabled? Yes, we're continuing the guardianship. Does this person have dementia? Yes, we're continuing it. But maybe that person is differently situated now. But the death of a person does not automatically terminate the guardianship. There will still be a bond. The person has to seek permission to be for the guardianship to be terminated. And the reason for that is the court wants to observe one more time the finances of the individual. This way, they can prevent fraud or any kind of malfeasance on the part of the guardian. There are specific things that have to be done after the death of an incapacitated person. They need to obtain the death certificate. They have to prepare a statement of death. It has to be filed with the court. They have to notify the court examiner, and the court examiner has to prepare a document for judicial signature. And the court will direct that within 150 days of that document, it's actually called a notice of death, the person prepares a statement of death, and the notice of death is the document that triggers the court to order a final accounting. And that's that last look, the last observance of the court to make sure that all of the money was handled. So $24,000 comes in on an annual basis, $2,000 a month. Rent is $1,200. Food is $400. In my example, there's $400 left a month. At the end of the year, that person should have $4,800. So that's a simplified example, but you have to look at all of the income and all of the expenses and outgoing money, what's remaining there, and does the balance on the bank account jive? Does it show that they had that sum of money? And if that sum of money isn't there, what happened to it? Was there an expense that they didn't account for? Maybe they put in a chair ramp. Maybe they had to buy a new couch. Maybe they had to buy a new bed, a new wheelchair. Maybe there was a legitimate purchase, but it has to be accounted for. And then the final report is the final accounting from the last annual filed to the date of death. And there's a process for this. It has to be filed by order to show cause. If you have any situation in your life where someone has the onset of a condition, right? The diseases of civilization, Alzheimer's, dementia, Parkinson's, right? Any person 65 years old or older, 50% of that population are going to need long-term care. Much of that is because they have faced an incapacity. Can you take any steps now to avoid this court process? Well, sometimes a power of attorney can be used, and if it's made properly by an elder law attorney, you can in fact avoid this type of guardianship. If you have a trust where you've directed a disability panel, that also can avoid this type of guardianship. I'll schedule an appointment with you, right? Talk about your situation, the specifics of your case. Who do you think needs guardianship? Why? Does it rise to that level? I just did a consult earlier in the week. The adult daughter wants to end the guardianship of her mother. Her mother was in the background. I only spoke to the adult daughter, but she was there and supplying some information. She sounded lucid. The guardianship actually started because the mother was being evicted, and the guardianship continued. So that may very well be a case where the guardianship does not need to continue. And I gave information and advice, but I handled this over the phone. If you either want to prosecute a guardianship or terminate a guardianship, I can handle that. To the extent possible, we try to anticipate the amount of work involved in an uncontested guardianship and give a fixed price. It's not always easy to do because I don't know who may come in and contest. And even if it's uncontested, no one is challenging the case. There are still at least, I want to say 3 court dates. That's rather typical. Documents are filed, a court evaluator is appointed. There might be that initial date that's a conference. We might have to wait for a second date to get the report of the court evaluator. And then on the third date, we might actually proceed to hearing. If it's uncontested, it should end that date. If it's contested by one of the 2 general methods of contact, of guardianship contest is, hey, 2 adults are fighting over whether or not the person is even incapacitated, or is it 2 adults fighting over who should be the guardian? Hey, we know the person's incapacitated. We want to fight over who's going to be the guardian. It should be me and not you. So the more the legal effort, the higher the fee. We have to prepare witnesses and evidence. It can be a couple of dates. It could be a couple of hours each date. So that's a little more difficult to calculate in a flat fee, fixed fee arrangement. But if I get the sense that it's going to be uncontested, I would do my best to quote a legal fixed flat fee. If you think of any questions afterwards, you can send me an email, frank@frankbrunolaw.com. My website is on the page, frankbrunolaw.com. I have a ton of resources there, more than 400 videos, frequently asked questions, the specifics of this area of practice. And if you have any other questions, please reach out to me by email. Thank you for attending. Congratulations for completing today. You know a little bit more about the guardianship process, and go out and make it a great day.